And this is the very first one, my lord, where the Senate voted to uphold, my lord. It is in public interest that the conservatory orders in place remain until such a time that the process that led to the Senate upholding this impeachment process is determined by this court, my lord.
So the public interest is that the issues laid out in the petition should be canvassed substantially.
Yes, as they continue receiving service from the person whom they elected into office, my lord.
Substantively as the people to receive services from the elected to office. We have about 2 minutes, 15 seconds.
My lord, I'm just making my winding remarks. My lord, the last issue in my submissions is whether the omission of the Senate from the proceedings render the petition incurably defective. I do not wish to regurgitate, as I said. I rely wholly on what was submitted by my learned senior, Mr. Ngoya, as well as what is in the text of my submissions, because it's a copy and paste, my lord.
Yes.
And as I finalize, I would like to state that even though the impeachment process is a quasi-judicial process, my lord, it is governed by the rule of law, which we are all called upon to uphold.
Yes.
I do not wish to state any further. I wish to rest my submissions there. Thank you very much, my lord.
Thank you. Council, you have 20 minutes.
Good afternoon, my lord.
Good afternoon. And you're the only one who's had the courtesy to wish me a good afternoon.
Yes. My name is Maya, once again. I'll be submitting on behalf of the second interested party, that is Federation of Women Lawyers, FIDA.
Yes.
To give a brief background, FIDA has an application to join the proceedings as an interested party on 5th of September 2016.
Please speak a little bit louder.
I know we could indulge my learned friend by giving this opportunity.
Please sit near a microphone.
Yes, the second interested party made an application to be joined as an interested party to these proceedings on 5th September 2024. In the hearing conducted on 24th and 25th of September 2024, by consent, it was agreed that the interested party to be allowed to be part of the proceedings. These submissions that I'm here to present, dated on 2nd October 2024, are made in support of the petitioner's application dated 21st August 2024 and in opposition of the respondent's application dated 3rd September 2024. Secondly, I associate with the submissions by the petitioner and the first interested party, and therefore will be very brief so as not to repeat what has already been said. For that reason, I will go straight to the issues that the second interested party put forward for determination in the matter. So the first issue is whether the petitioner has met the threshold for issuance of conservatory orders. Secondly, is whether the ex parte conservatory orders issued on 21st August 2024 ought to be reviewed, varied, set aside, and or discharged. And third, who bears the cost of this application? To the first issue is whether the petitioner has met the threshold for issuance of conservatory orders. I do not wish to repeat the principles that have been stated by the petitioner's counsel. However, I wish to highlight that conservatory orders are granted on the inherent merit of a case, bearing in mind public interest, the constitutional values, and the proportionate magnitude and priority levels attributed to the relevant case. Further, conservatory orders are issued in exercise of the discretion of a court.
Yes.
The second interested party relied on the case of Gatirao Peter Munya versus Dixon Mwenda Kithinji and two others. That's at 20. The citation is 2014 EKLR for the courts that have made on the conservatory order being public in nature. And therefore, what is more important in this case is that the constitutional edict to be protected and that it be observed by members of the Senate and of the County Assembly elected as representatives of Kenyans, the citizens of Kenya. Therefore, misuse of such powers that the members of the County Assembly and the Senate have should not be allowed by the court. It is on this premise that we implore the court to uphold the conservatory orders and that the same to not be set aside. On to my second issue on the exercise of discretion by the court. My Lord, the court is alive to the social constructs in Kenya, the patriarchy in our societies, and the general dynamics of our society.
Just a moment, Counsel. Did FIDA file an affidavit?
No.
So I think we can just skip the observations about the general nature of our society. Unless they are founded on an affidavit, those we cannot read and rely on.
I am guided. Having said that, that is the end of my subject.
You had outlined a third issue, of course. You had outlined a third issue.
I adopt the submissions and pray that the court rely on those in determining the matter of costs.
Thank you, Counsel.
Thank you, Your Lordship. Allow me on behalf of the third interested party to urge you, Your Lordship, while the conservatory orders were not deserved and ought to be discharged. My Lord, you rely on our written submissions dated the 30th of September 2024.
Dated
30th September 2024, and the case laws embedded on those submissions, Your Lordship.
Yes.
My Lord, I will submit to you on 3 limbs. The first is on public interest. My Lord, the second is on the question of nugatory. And my Lord, lastly, on the balance of convenience. My Lord, my departure point is Article 1 of our Constitution,
Yes.
and which, my Lord, provides that all the sovereign power belongs to the people. And my Lord, under Article 2, the people are allowed to exercise that sovereign power either directly or through their elected representatives.
Yeah.
My Lord, the people of Meru County, through their elected representatives being the members of the County Assembly,
Yes.
elected to impeach their governor.
Yes.
My Lord, the propriety of the procedure which they followed was clear, and I believe it has been well explained by the respondent in this petition. My Lord, public interest, I would want you to be guided on what the Supreme Court has said in petition number 10 and 11 consolidated of 2024. That is the case of Dock Workers Union and Okio Mutata versus KPA and others.
Yes.
And Your Lordship, the Supreme Court was very, very candid that the third ground that a court should consider while granting or denying conservatory orders is the impact of such orders beyond the parties to the case, and should the order be granted or denied, what is the or maintain the conservatory order, as this petition is going to be rendered nugatory. My Lord, we humbly submit that the position of a governor, with all due respect, Your Lordship, is not personal to any individual. It is a constitutional office. The holders of that office are public officers within the meaning of the law.
Yes.
My Lord, no person can cling or individualize the position of a governor. As such, Your Lordship, the law provides for mechanisms of removal of a governor, and that is exactly what has happened in the matter before you, my Lord. My Lord, it is trite, and the court was kind enough to read our mind, which is also in our submissions, that indeed, even if the governor was to be found to have a meritorious petition before you,
Yes.
you have powers to reinstate her to office. My Lord, you have powers to order that she be paid damages. My Lord, again, you have powers to issue any appropriate orders that will remedy her as a person of the governor. My Lord, as such, Article 182, Sub-Article 2 of the Constitution also provides why there will be no vacuum, because a deputy governor will be able to take office and discharge the functions of a governor. As such, Your Lordship, there is no issue of nugatory or the petitioner or the petition being rendered nugatory before you, because the law has provided safeguards, sufficient safeguards over such a matter.
Yes.
My Lord, if you allow me again, I had my colleagues submit that there is no way of dealing with a deputy governor who presumes office. And my Lord, I would want to refer him to Article 182, Sub-Article 6 of our Constitution,
Yes.
which provides that a deputy governor can as well be removed.
Article 182, Clause 6.
Sub-Article 6,
Yes.
which, my Lord, provides that a deputy governor can as well be removed if he does not act within the Constitution. provisions. My Lord, you've also been told that the petition will be rendered nugatory because the county executive committee and the cabinet will be kicked out of the office because the governor has been impeached. My Lord, with all due respect, that position is inaccurate. Those persons are constitutional office holders, elected or nominated or given that power pursuant to legal provisions. In fact, their terms run for 5 years. And my Lord, the mayor, deputy governor, does not mean that those persons will as well go home. My Lord, you've also been urged that in regard to Section 33(8) of the County Government Act, and my Lord, is a humble submission before you that that provision of the law enjoys the presumption of constitutionality. My Lord, in any event, and with all due respect again, the issue of Section 33(8) in Meru, which is still pending and which has not been prosecuted. My Lord, with all due respect, without going into the facts of the matter as an interested party, you are urged that there was an existing court order barring the impeachment process. My Lord, our first question is, was the Senate a party to those proceedings? My Lord, our second question is, if indeed there were proceedings that barred the impeachment process, as the petitioner filed in the contempt application in that court. And my Lord, if they want you to deal with the issues of Section 33(8) of the County Government Act, have they sought a consolidation of the two petitions so that this court is then embodied to deal with that issue? My Lord, with all due respect, we feel that those facts have not been brought before you in the proper way, and you are being enjoined and you are being misled, with all due respect, where there is not material disclosure of the proper facts on the ground, and upon which your Lordship was misled to issue a conservatory order. My Lord, as I wind up argument on that point, I wish to remind ourselves that the term of the petitioner as an elected governor is not indefinite. It's only limited to 5 years. The law anticipated that that term can be stopped or curtailed through a legal process. That is what has happened, Your Lordship, and there is nothing illegal about that. As such, the petition before you cannot be said that it will be rendered nugatory when a legal process has taken place. My Lord, allow me to go into the question of balance of convenience.
Yes.
Your Lordship, allow me to pose a question. What would happen if Your Lordship maintains the conservatory orders in this matter and eventually finds that the petition before you is not merited? My Lord, the people of Meru, the voters of Meru, one of whom I represent before you, will continue the suffering they have endured since the governor took office, and they are enduring in the current stalemate in Meru County. And Your Lordship,
apologies, I object to that. A learned colleague like my other learned colleague didn't file an affidavit. The question of people of Meru suffering is a purely factual issue that can only be brought to the attention of this court of an affidavit. I urge that he be stopped in his tracks from submitting such a factual issue without an affidavit, because we want to know the particulars of suffering, or that we deal with them one by one.
Mr. Karimi.
Yes, Your Lordship.
Please limit yourself to the scope of your submissions.
Thank you, my Lord. I will limit myself. I urge Your Lordship to look at the facts from the parties who have filed affidavits of fact. Thank you. My Lord, on the balance of convenience, I was submitting that in the event that you find that this petition was not merited, and by that time the voters of Meru County will have endured the lack of a proper governor for the county. And that, my Lord, with all due respect...
Mr. Karimi,
yes, my Lord.
Mr. Ngoy has not raised to his feet, but I think you can reword that.
Thank you, my Lord. Thank you, my Lord. Thank you, my Lord. My Lord, allow me to leave that and move to my second limb of argument, why the balance of convenience, my Lord, we feel that favors the lifting of the conservatory orders. Yes. My Lord, we humbly submit that it will have been, with all due respect, unfair to the people of Meru County to have endured a process whereas they could have sworn in their deputy governor and proceeded with the management of the county affairs, while the governor finds justice in the petition before you without a conservatory order being in place. My Lord, with all due respect, we also want to look in the question of the status quo.
Mr. Karimi,
yes, Your Lordship.
If I'm to understand that point that you just made, you're saying that there is a balance of convenience where each party, each side gets something. So the voters get a new governor, the petitioner gets to argue their case, and at the end of the process, if the court reverses the decision and the actions that were made, so be it. If not, then no harm is done. Is that what you're saying?
My Lord, we are saying more than that, in the event the court finds that the petition is also merited, it is clothed with sufficient means of remedying the governor. It can order damages, it can order reinstatement, it can issue appropriate orders, Your Lordship, that will assuage the governor.
I'm trying to see how you can frame this without having to fight an affidavit, because you do represent the interested party who is admitted because they are a voter. Perhaps it is impossible.
Thank you, Your Lordship. Thank you, Your Lordship. My Lord, I wish to also submit that the question of status quo as escalating from the Senate,
yes,
and as escalating from the members of the County Assembly of Meru who are not parties in these proceedings,
yes,
is that their governor stands impeached.
yes.
My Lord, in my humble view, the balance of convenience tilts in favor of maintaining the status quo that has been adjudicated by at least another arm of government.
Yes.
My Lord, we further urge you that the facts, and if you allow me, this goes to the issue of joinder, which we've also submitted on, the fact that, Your Lordship, the members of the County Assembly were not enjoined in these proceedings, neither was the Senate itself enjoined in these proceedings. We humbly submit that that omission is fatal for the following reason.
Yes.
My Lord, the mover of the motion of impeachment, the owner of the motion of impeachment, is the people of Meru through their elected representatives. With all due respect, Your Lordship, they are the mothers of the motion. My Lord, failing to enjoin them in the proceedings before you, we humbly submit was mischievous, with due respect to my colleagues. And Your Lordship, I wish to distinguish the case that was cited before you by my colleague, that is the Speaker of National Assembly versus the Center for Rights of Educational and Awareness and 7 others.
Yes.
My Lord, that particular matter before the Court of Appeal did not emanate from impeachment proceedings.
Yes.
My Lord, the role of Senate in impeachment proceedings is unique and peculiar. My Lord, the role of the members of the County Assembly, again, in the impeachment process is also quite unique.
Yes.
As such, Your Lordship, the non-joinder of parties in that particular matter, where the court said did not go to the issue, did not affect the fundamental rights of the parties, cannot be the same as a matter involving impeachment of a governor. And as such, Your Lordship, that matter is not on all fours like the matter before you, and is quite distinguishable. My Lord,
going through your submissions,
yes, Your Lordship.
and also those of the respondent,
Yes, Your Lordship.
there was quite some ground covered as to prejudice, where essentially this court is being invited to interrogate the constitutionality of parties that are not before this court. You've alluded to it being the Senate and then the County Assembly. Can this court safely give orders at the end, or even at the interlocutory stage, that affect parties that are not before this court?
My Lord, we humbly submit that this court should not issue orders affecting parties who have had an opportunity to espouse their position before you. Your Lordship, I wish to remind the petitioner, perhaps, that the person they have sued, that is the Speaker, does not even hold a voting right in Senate. So the Speaker is not per se directly the owner of the motion that went on to impeach the governor. The real people who impeached the governor is the Senate and the members of the County Assembly from Meru, whom my client participated in electing. Your Lordship, allow me to also submit on just one issue, the one you asked about mischief, and I think we had submitted a bit on it.
That is your time, but I'll give
Thank
a
you.
bit more.
Thank you, Your Lordship. Thank you for indulging me. Thank you. My Lord, with due respect, the Senate, understanding orders 111, foresaw the mischief that can be perpetuated.
The Senate at standing order?
111.
Yes.
Foresaw the mischief that can be perpetuated during a motion of impeachment, like the one that emanated the proceedings before you. And as such, Your Lordship, they limited the question of the debate of that motion. And again, in the wisdom of Senate and our constitutional makers, they also gazetted the days and the timelines for debating such motions. Your Lordship, I'm trying to go around the issue that was raised by the petitioners, that there was communication that came out erroneously without appearing to go into the facts of the issues. And my Lord, we humbly submit that that issue is amply covered by the respondent, and that mischief was cured, and that is why the communication and to come on the 20th of August, because time froze, whether it was midnight or past midnight, time froze until the motion was debated and concluded. Finally, Your Lordship, with all due respect, allow me to associate fully with the submissions made by the respondent before you, and urge Your Lordship to kindly vacate and set aside the conservatory orders that are in place and that have made the people of Meru continue suffering. My Lord, good afternoon.
Good afternoon to you. I'm glad it's catching on.
Thank you.
Mr. Ngoya, you had indicated